In this lecture, we'll talk about a specific area of campaign finance law, the law that deals with political parties and interest groups. And so just to give a roadmap of where we're going to go, the sort of questions that we'll ask and answer are: first, how does campaign finance law treat political parties? Secondly, what are the different types of interest groups that are relevant to campaign finance law? And then third, what's the difference between issue advocacy and express advocacy, and why should we care? So let's review the basics, first of all, from the last lecture, which concerns the Buckley framework. The Buckley framework, as you may remember, subjects to contributions, what's known as Buckley scrutiny, a special form of intermediate scrutiny, that asks the question whether the contribution limit is closely drawn to prevent corruption or the appearance of corruption. That's designated by the horizontal line in this diagram. The dotted lines going off into space, those are independent expenditures. And as you remember from Buckley, independent expenditures by outside groups, by contributors, by candidates, those regulations of independent expenditures are subject to strict scrutiny, meaning that they must be narrowly tailored to serve a compelling state interest. And for that matter, most regulations of independent expenditures are therefore going to be unconstitutional because strict scrutiny is strict in theory, but fatal in fact. Political parties add a bit of complexity to that diagram. So having an intermediary between the contributors and the candidates raises a lot of questions. As you can see from this new diagram, the questions we're going to be asking today are whether contributions to political parties and contributions from political parties should be subject to a special type of scrutiny, and whether their independent expenditures should also be treated like those of other outside groups and subject to strict scrutiny, and likely that regulations of those independent expenditures would be unconstitutional. Just to forward to the end here, what we will learn is that Buckley scrutiny applies to contributions to political parties and from political parties, and as with other outside groups, their independent expenditures are going to be subject to strict scrutiny and likely be unconstitutional if they're regulated. So here are the conceptual challenges that are posed by political parties. First, are they just like other outside groups or associations? You may remember from the party autonomy cases like California Democratic Party versus Jones, Tasjian versus Republican Party of Connecticut, that political parties are seen as having robust First Amendment rights, just like some other outside groups and organizations. But second, are they like office holders and candidates? Because we know that from the white primary cases that in some instances we view parties as state actors who are subject to constitutional obligations as well as possessing of constitutional rights. Third, specifically from the standpoint of campaign finance, can parties corrupt candidates, or can they serve as conduits for corruption of outside contributors? Fourth, even if they might not be able to corrupt candidates, can they themselves be corrupted by contributors? Because if parties are, as often is the case, sort of collections of office holders, then it's possible that they might be corrupted by outside contributions. Fifth, can party expenditures ever truly be independent? As we've discussed in other contexts, the Supreme Court's jurisprudence from Buckley and his progeny is that if something is an independent expenditure, then it is treated as core First Amendment activity and subject to strict scrutiny if you try to regulate it. But are political parties different in that they are never really completely independent from their candidates? And so can we talk about independent expenditures by political parties? Sixth, regardless of how we might conceive of the constitutional rights of these political parties, is it desirable to restrict the ability of political parties to coordinate with their candidates, if that's what the constitutional law would in effect require? And then finally, how should the law account for the confederated nature of political parties, which exist at the federal, state, and local level? So while we're talking about political parties in the abstract, there is no sort of one thing which is a political party. They exist at many different levels of government as well as in their kind of formal and functional capacities. So those are the conceptual challenges that political parties pose. To just emphasize what the general rule is that comes out of cases like Colorado Republican 1 and 2 and McConnell versus FEC, parties are treated like other outside groups. Their contributions to candidates can be regulated consistent with Buckley scrutiny, meaning that they must be closely drawn to prevent corruption or the appearance of corruption. But that if a party's expenditure is truly independent, and that's an important caveat, if a party's expenditure is truly independent, then they're just like other outside groups in that restrictions on their independent expenditures are subject to strict scrutiny. Now, finally, as is going to become clear in the cases we're about to discuss, Colorado Republican Federal Campaign Committee versus FEC, the coordinated expenditures of political parties are treated like contributions. So now you got to know what a coordinated expenditure is. A coordinated expenditure is basically an expenditure that's done in concert with or with some agreement with the candidate. And so the federal election campaign laws had a series of limits on coordinated expenditures between parties and candidates because it was assumed that the political parties would, in fact, have agreements with their candidates to spend certain money. As we'll see in the next cases, it's an empirical question as to whether a given expenditure is coordinated or independent. So now let's talk about FEC versus Colorado Federal Campaign Committee 1 and 2. These are two cases, one in 1996 and one in 2001, the same plaintiffs and defendants. The facts in this case are kind of interesting. And as it first came up to the Supreme Court in Colorado Federal Campaign Committee 1, the committee bought ads targeting an incumbent Democratic senator, but it was before a Republican candidate was even nominated. The FEC said that it violates the legal limit on coordinated expenditures. Now, what the court held was that the coordinated expenditure limit is unconstitutional as applied to this kind of expenditure because you cannot just treat an expenditure as coordinated when there's no candidate that yet exists with whom you could coordinate. So let me just explain that. In this case, the Republicans were basically buying attack ads against the Democratic senator, but there wasn't a new Republican candidate with whom they could coordinate. And so if you were going to say that this could be limited because it was kind of like a contribution, which a coordinated expenditure would be, there was nobody that they could contribute to. There was no candidate yet on the Republican side. And so this was one of these unique cases where it was truly an independent expenditure because there's no way that you could say that this was done with some agreement between the party on the outside and the candidate that they were supporting. So there was no risk of corruption because there was no recipient of what would have been a quid pro quo. And so the holding in Colorado Federal Campaign Committee 1 is that you have to look at these expenditures in a kind of functional way. Was it an actual independent expenditure, in which case it is protected First Amendment speech just like other expenditures protected by Buckley? Or is it truly a coordinated expenditure, which then could be treated like a contribution? Now, there are a range of perspectives in the case, with Justice Stevens and Ginsburg saying that you could regulate both party expenditures and contributions. Remember, Justice Stevens was pretty much an opponent of Buckley in the fact that it would protect unlimited campaign expenditures. So it's not surprising that he would say that you could regulate both party expenditures and contributions. It's also not surprising that Justice Thomas, joined by Justices Scalia, Kennedy, and Rehnquist, said you couldn't regulate either, that strict scrutiny should apply both to contributions and expenditures in the party context as well as outside the party context. But ultimately, the majority, the plurality, and then the majority in the second case, have come up with the rule that you can regulate contributions, meaning also coordinated expenditures, but you can't regulate independent expenditures, which would be a regulation like that would be subject to strict scrutiny. And I should emphasize that in the second case, in Colorado Federal Campaign Committee 2, the court upholds against a facial challenge, the challenge to the coordinated expenditure limit, meaning that you, the government, are able to regulate the amount of money that a political party would spend in concert with a candidate for the same reason that you can regulate the ability of a political party or any other outside group to make contributions to candidates, that when there's coordination, there's a risk of corruption. So now let's talk a little bit about parties and corruption and how it's conceived by the different justices in Colorado Republican 2. So, and I want to emphasize that these notions are important, not just for these particular cases, but they become the kind of way that the court analyzes the risk of corruption with political parties in cases like McConnell versus FEC. So the court emphasizes sort of two aspects of corruption when it comes to political parties. The first is the notion of conduit corruption, and the second is the notion of the importance of limits on parties in order to prevent circumvention of the individual contribution limits. So let's just read a bit from Colorado Republican 2. What the court says there is that parties are the instruments of some contributors whose object is to support a specific candidate for the sake of a position on one narrow issue, or even to support any candidate who will be obliged to the contributors. Whether they like it or not, they, the parties, act as agents for spending on behalf of those who seek to produce obligated office holders. Donors can use parties as conduits for contributions meant to place candidates under an obligation. What the court is saying here is that if the court were to take a different view in Colorado Republican 2 and say that, parties are perfectly allowed to coordinate with candidates and to contribute as much as they want, well, then individuals would give money to political parties in order to have that money go directly to the candidates. That's where the parties would serve as a conduit. And that one of the reasons you need to plug up the potential loophole of the conduit from contributors through parties to candidates is to prevent evasion of the individual contribution limits. As the court says, if a candidate could be assured that donations to a party could result in funds passed through to him for spending on virtually identical items as his own campaign funds, a candidate enjoying the patronage of affluent contributors would have a strong incentive not merely to direct donors to his party, but to promote circumvention as a step toward reducing the number of donors, requiring time-consuming cultivation. In order to prevent contributors from corrupting candidates, you also have to shut down both sides of the conduit, or at least limit the amount of money that could go from a contributor to a party and then from a party to a candidate. Now, the dissenters in Colorado Republican 2, led by Justice Thomas, their view is that, look, the parties are different kinds of actors. We shouldn't think of them in the typical Buckley mold. The very aim of a political party, Justice Thomas says, is to influence its candidate's stance on issues, and if the candidate takes office or is reelected, his votes. One can speak of an individual citizen or a political action committee corrupting or coercing a candidate, but what could it mean for a party to corrupt its candidate or to exercise coercive influence over him? As Justice Kennedy said in his dissent in Colorado Republican 1, parties are inextricably intertwined with candidates, so that when you limit coordinated spending or even contribution between a party and a candidate, it can cause a stifling effect on the ability of the party to do what it exists to do. And so he says it makes no sense, therefore, to ask, as FICA does, whether a party's spending is made in cooperation, consultation, or concert with its candidate. The answer in most cases will be yes, but that provides more, he says, not less justification for holding unconstitutional the statute's attempt to control this type of party spending. So for the dissenters, they think that parties are different types of actors in the campaign finance system. That the idea that the campaign finance laws would drive a wedge between parties and their candidates makes no sense. That we want a political system in which parties are closely aligned and coordinating with their candidates. And if you sort of uniquely disable political parties by preventing them from raising the money that they need or preventing them from spending and contributing money to candidates, you are essentially undermining the very function of a political party and its associational rights. For Justice Stevens in dissent, the fact that parties are inextricably intertwined with their candidates provides an argument for why you need to be particularly careful in regulating them. As he says, a party shares a unique relationship with the candidate sponsors because their political fates are inextricably linked. That interdependency creates a special danger that the party or the persons who control the party will abuse the influence it has over the candidate by virtue of its power to spend. And so here you see two very different views of political parties. One is that we need to cultivate the relationship and have a campaign finance system which is friendly to the idea that parties will coordinate with their candidates and spend money on their behalf. Whereas Justice Stevens, who's always concerned about corruption and fraud and sort of the sort of dark shadows in the campaign's finance system, his view is that because of the close relationship between parties and candidates, we need to be especially vigilant about making sure that the parties don't corrupt their candidates or their nominees. So these rationales that come out of Colorado Republican 1 and 2 then become relevant with respect to the litigation on the Bipartisan Campaign Reform Act. So this lecture will talk a little bit about one of the sections of the BCRA or McCain-Feingold. The next lecture, which will talk about Citizens United, will talk about the second aspect of the Bipartisan Campaign Reform Act. Just to give you a very short description of what the Bipartisan Campaign Reform Act did with relevance to the topic we're discussing now, the BCRA sought to plug loopholes that had allowed unregulated money into the campaign process through parties and independent expenditures. It banned what's known as soft money, and that was upheld by McConnell versus FEC. And then it banned corporate union expenditures on electioneering, which was originally upheld by McConnell, but then struck down by Citizens United versus FEC. So let me explain first what the soft money ban in the Bipartisan Campaign Reform Act was about. It banned corporate and union treasury contributions to national political parties. Although the original Federal Election Campaign Act, and as well as earlier efforts at legislation, had banned corporate and union treasury contributions to political parties, because of FEC interpretations, because of the way that the contributors had used sort of loopholes with state parties, there was a lot of corporate and union money in the 1990s that was coming into the system. And so the Bipartisan Campaign Reform Act made a sort of bold regulatory statement, that no money from corporate or union treasury funds could go into national political parties. And it couldn't go into state political parties for federal electioneering activities, because that was another loophole, that if you couldn't give money to the national parties, maybe you would give it to the state parties, which would also spend on actual federal campaign activity. Now, that's what I was saying with respect to corporate and union donations. And then what it did with respect to individual contributions was to maintain that individuals could contribute to political parties, but they could only do so within limits. And so the soft money ban was just a way of trying to make sure that any money that was coming into and out of political parties would be regulated, but both banning certain sources, corporate and union treasury funds, but regulating individual contributions. And the Supreme Court in McConnell versus FEC upheld the soft money ban. And it did so based on the sort of lowered definition of corruption that came out of cases from Buckley through Nixon versus Shrink Missouri Government PAC that we've talked about in previous lectures. So you may remember that Nixon versus Shrink Missouri Government PAC had held that, corruption is not just about quid pro quos, but it's also about undue influence on an office holder's judgment. And so here in McConnell, the court applies Nixon's liberal notion of corruption and the appearance of corruption to include the broader threat from politicians too compliant with the wishes of large contributors. Corruption was not sort of given the narrow interpretation that, as we'll see, Citizens United gives, but it also included favored access, manipulation of the legislative calendar, these ideas of conduit corruption and in the anti-circumvention rationale that came out of Colorado Republican 1 and 2. But it was an expansive view of corruption, so that it was not just about money buying favors from politicians. It also included things like whether money bought people access, regardless of whether that ended up leading to differences in votes, as well as this larger notion of the appearance of corruption, that if people or corporations are giving large checks to political parties, that even if they aren't technically corrupted, or you can't prove that it has an effect, that there's an appearance of corruption there that is also worth considering. And that was, of course, upheld in both Buckley in Nixon versus Shrink Missouri Government PAC, and then later in Randall versus Sorrell. Just to be clear, this notion of corruption that comes out of McConnell versus FEC is narrowed significantly in Citizens United versus FEC. But I want to at least put this on the table, even though it's sort of partially overturned. because it is still the case that the soft money ban is in effect. So that McConnell versus FEC, this part of it is good law with respect to at least the holding that corporations and unions can be banned in contributions from their treasury funds to political parties, and that individual contributions can be limited to political parties. The concerns about corruption are sufficient to justify both the limits on individual contributions to parties and the ban on corporate and union donations. So here's where things stand with respect to political parties and campaign finance as we enter 2023. Contributions from contributors to political parties are subject to Buckley scrutiny, just as contributions from contributors to candidates are subject to Buckley scrutiny, meaning they must be closely drawn to prevent corruption or the appearance of corruption. The same is true with respect to contributions from political parties to candidates. Those are treated just like contributions from other outside groups. But expenditures from all three of these entities, whether it's contributors or political parties or candidates, if the expenditures are truly independent, then restrictions on them are subject to strict scrutiny, and so they're likely to be struck down as violating their First Amendment rights. And so political parties from these cases are not seen as special institutions. They're seen as just like other outside groups whose contributions to candidates could be seen as corrupting. Now, there is a kind of political science take of a critique of this regulation of political parties in the campaign finance realm. And that sort of comes out of those concerns that were expressed by Justice Thomas in his dissent in Colorado Republican 2, which is, does the campaign finance system sort of uniquely hobble political parties, which serve a very important purpose in our political system? Second, to what organizations, if not to political parties, should money be channeled toward insiders or outsiders? Because some believe that it's important to have the money flow toward political parties as opposed to outside groups, which might not be very accountable. And so if the money goes to political parties, at least we know who those officials are, as opposed to these outside groups like super PACs or 501c4 organizations that we'll discuss, where it might be much less transparent. Furthermore, what are the consequences for polarization in campaigns if outside groups are better funded than official political party organizations? Because that's something that we're seeing nowadays, which is that super PACs that are not necessarily beholden to the political party or to the official sort of organizations of candidates end up being major players in the campaign finance system, whereas the political parties, who serve a very important aggregating function and policymaking function, might have particular restrictions on their ability to raise money and to spend money. So now let's talk about these other actors in the campaign finance system, which we'll loosely call interest groups. And so an entire lecture could be given on the different types of interest groups as recognized both in the campaign finance laws and in the tax law. And so let's briefly put up the definitions of these different groups. The first is political action committees. Now, political action committees are legal creations. There's no sort of political action committees in the wild. You register with the FEC as a political action committee when you receive a certain number of contributions, and then you disperse contributions in under $5,000 increments, right? Political action committees are a specific entity as regulated by law. But they were created in order to be repositories for outside groups that then, or outside contributions that would then lead to sort of an aggregation of individual money in order to give to candidates and political parties, but under restricted limits, right? So their contributions, just like contributions from parties, are limited. Then there are super PACs, right? So what makes a political action committee super? Well, these are what are known as independent expenditure committees, and we'll talk about how they were created after the court's decision in the lower court's decision in Speech Now versus FEC. But an independent expenditure committee, or super PAC, is one that receives money from all kinds of sources, but commits not to transfer that money to candidates or to engage in coordinated spending with those candidates. So it is truly independent from the candidates themselves. And so therefore, a super PAC is allowed to raise unlimited amounts of funds and to spend unlimited amounts on electioneering activity, because it is a truly outside group, or at least that's what sort of the legal fiction is that there's no possibility of corruption from the super PACs to the candidates through their mere independent expenditures. Then you have a series of groups that are defined by the tax law. So there's overlap between them and these official groups inside that are defined by the federal election laws. So 527 organizations are political organizations that are organized and operated primarily for the purpose of directly or indirectly accepting contributions or making expenditures, or both, for the function of influencing or attempting to influence the selection, nomination, election, or appointment of any individual to federal, state, or local public office. And so that's under the tax laws that we designate certain organizations as 527 organizations. There are there are party organizations that are 527 organizations, super PACs, PACs. That's just a designation under the tax law. It's not terribly important, except that 527 organizations had been, until the advent of super PACs, major organizations that had been spending money independently in the political process. Then you've got 501c4 and 501c3 organizations. 501c4 organizations had risen to importance in the sort of late 2000s, early 2010s. These are technically under the tax law, social welfare organizations that are primarily engaged in promoting in some way the common good and general welfare of the community. Those words, primarily engaged, are quite important for the definition of a 501c4 organization. A 501c4 organization can engage in election-related activity, but it just cannot be its primary purpose. And so what's happened in recent years is that 501c4 organizations have become the repositories of hundreds of millions, if not billions of dollars of campaign funds that are then used to affect election outcomes, but they are not necessarily registered and part of the kind of same campaign finance infrastructure that PACs and super PACs are. And so that's why people often refer to 501c4 organizations as dark money organizations, because there's much less transparency related to 501c4 organizations. And the law, again, is that they cannot be primarily engaged in electioneering activity, but a significant share of their funds often will be dedicated toward elections. And then finally, you've got 501c3 organizations, which are charitable organizations. 501c3 organizations are often involved in elections, but they can't be involved in sort of candidate political activity or in strictly election-related activity. But many of them will run advertisements on issues that might have an effect on an election. But as a general rule, 501c3 organizations, charitable organizations, cannot participate in campaigns. The most significant phenomenon when it comes to recent campaign finance developments is the rise of super PACs. Super PACs were basically created by the courts in the aftermath of Citizens United, because Citizens United, as we'll soon see, upheld the ability of corporations to spend unlimited amounts on express advocacy, advocating the election and defeat our candidates. Super PACs are, as I said before, just political action committees that are not coordinating with candidates or parties. And so the super PACs are able to raise unlimited amounts of funds and spend unlimited amounts of funds, so long as they abide by that restriction that they're not coordinating with candidates or parties. The DC Circuit in 2010 came to this conclusion in part because of what was a more anemic or narrowed version of corruption that came out of Citizens United, because Citizens United made it very clear that there isn't a risk of corruption from independent expenditures or from contributions to committees that are solely engaged in independent expenditures. And so that's what makes a super PAC super. It can spend unlimited amounts of money and raise unlimited amounts of money, but in order to remain a super PAC, it cannot coordinate with candidates or parties. So one last topic I want to cover in this lecture that will set the stage for the discussion of Citizens United is the difference between express advocacy and issue advocacy. It becomes quite important because, to the extent that we might try to distinguish between electioneering activity, like activity that specifically is going to affect an election, as opposed to just discussion of issues. That becomes important with respect to disclosure provisions, the corporate and union spending ban, which was struck down in Citizens United. It's also relevant to foreign nationals who are prohibited from engaging in electioneering communications. It also happens to be relevant to the way the internet platforms are regulating advertising. Several of them will ban express advocacy, paid advertising that endorses candidates, but will allow issue advocacy. So the basic idea between express advocacy and issue advocacy is that express advocacy refers to speech that is advocating for the election or defeat of candidates, whereas issue advocacy refers to political speech on issues. It's basically any political discussion that's not considered express advocacy. And you might think that, look, why should it make a difference? The First Amendment should protect your ability to talk about candidates just as it would talk about issues. But as you see in the dissents in the relevant cases, there's always a concern that express advocacy, specifically sort of spending on advertisements and other speech that engages in specific candidate advocacy, that there might be a special corruption threat that from that kind of spending, whereas spending on issues is just like what people do in the normal course of political advocacy, whether we're in the context of an election or not. The Buckley court actually dealt with the division between express advocacy and issue advocacy in the context of its adjudication of the expenditure ban or the expenditure restrictions in the original Federal Election Campaign Act amendments. And so there's a famous footnote 52, called the magic words footnote in Buckley versus Vallejo, where the court just tries to distinguish between express advocacy and issue advocacy. And the court construes the provision limiting expenditures relative to a clearly identified candidate. And it construes it to communications containing express words of advocacy of election or defeat, such as vote for, elect, support, cast your ballot for, Smith for Congress, vote against, defeat, reject. And so you can see why this is called the magic words footnote. There are specific words that are in that footnote that would be the classic forms of express advocacy. One thing that's come up in later cases is whether those magic words are really magic. Are they about those particular kinds of words, or is it generally sort of words that are like that would include advocacy for the election or defeat of candidates? Now, it can be very difficult to distinguish express advocacy from issue advocacy because many, if not most, campaign commercials don't contain magic words. In some ways, the most effective campaign commercials don't need to advocate for the election or defeat of candidates. Some of the most familiar ones are ones that are attack ads that say how terrible a candidate is, but then at the end they say, call this candidate to tell them how dissatisfied you are. So no words of express advocacy saying you should vote against or vote for a candidate, just saying how terrible your opponent is and that you should call that person to tell them how terrible they are. One of the most famous attack ads was one against a congressional candidate named Bill Yellowtail, but it's pretty much par for the course when you look at attempts to engage in electioneering, but to do so without words of express advocacy. So take a listen to this famous ad against Bill Yellowtail.
Who is Bill Yellowtail? He preaches family values, but he took a swing at his wife. And Yellowtail's explanation? He only slapped her, but her nose was not broken. He talks law and order, but is himself a convicted criminal. And though he talks about protecting children, Yellowtail failed to make his own child support payments, then voted against child support enforcement. Call Bill Yellowtail and tell him we don't approve of his wrongful behavior.
So you can see from this ad that there weren't words of express advocacy that were used. It was just an attack ad on Bill Yellowtail. And it ends with, call Bill Yellowtail and tell him we don't approve of his wrongful behavior. Doesn't say vote against, doesn't say vote for, but it's pretty clear from the content of the ad what the intent of the spender was. In order to get at these kinds of problems in terms of independent expenditures, The Bipartisan Campaign Reform Act had a special definition of electioneering communications, which we'll deal with it more depth in the next lecture. But just to tee it up, the Bipartisan Campaign Reform Act said that any broadcast cable or satellite communication that refers to a clearly identified candidate for federal office and is made within 60 days of a general or 30 days of a primary election and is targeted to the relevant electorate, that would then mean that this electioneering communication would be regulable under federal law. For the BCRA, that meant that no corporate or union treasury funds could be spent on those kinds of ads. But you can see that it doesn't say have magic words in the statute. It doesn't say that it's express advocacy. It's just references to candidates within a certain period before an election would then be deemed to be express advocacy. So in the next lecture, we'll talk about how this plays out with Citizens United, because ultimately this will be struck down as unconstitutional under the First Amendment.